Ready, start. Communication issued by the Principal Secretary to Revenue Department to all the district collectors and all chairmen of the Taluka Land Board in the state, requiring them to keep in abeyance the operation of Section 7E of the Kerala Land Reforms Act brought in by the Amendment Act of 2005 is essentially the subject matter of challenge in this writ petition. Since what has been interdicted in the communication affects the rights of the public in general, I think it is necessary to express the opinion of this court in certain categoric terms and see that it is brought to the notice of the government at its highest level and to the notice of the person who are at the helm of the affairs of the government, hoping that they will be gracious enough to spare some time and consider the aspects highlighted in the judgment. Petitioner purchased an extent of 8 acres, 49 acres as 5% separate documents executed in the year 1994 and 1995. According to the petitioner, it is derived rights over 13 acres of land from its predecessors in interest. Apparently, the right was being exercised by the predecessors in interest for a period of 30 years. The property was acquired for the purpose of establishing a school. While so, the petitioner received a notice stated to have been issued under the Kerala Land Conservatory Act 1957 stating that they have encroached upon 15 acres of government land and requiring them to show cause why they should not be evicted. Para. Subsequently, an order was passed by the competent authority requiring the petitioner to vacate land in number 20/1 of the village. Petitioner submit an appeal before the sub collector, but the same was rejected under Exhibit P1 order. Thereafter, petitioner has submitted Exhibit P3 statutory appeal before the district collector, the third WP number 25074 of the 2008 respondent. Normally, a direction to the district collector to pass orders on Exhibit P3 would suffice. Petitioner points out that no purpose would be served in prosecuting the remedy before a statutory authority in the light of Exhibit P2 communication issued by the Principal Secretary to the Revenue Department. The same reads as follows: I am to direct you to keep the operation of Section 7E as envisaged in the Kerala Land Reforms in bracket Amendment Act 2005 in bracket Act 21/06 bracket close in abeyance until further orders. I heard learned counsel for the petitioner and the learned government pleader. Notwithstanding anything to the contrary contained in Section 74 or Section 84 or in any other provisions of this Act or in any other law for the time being in force or in any contract, custom or usage or in any judgment, decree or order of any court, tribunal or other authority, a person who at the commencement of the Kerala land reforms in bracket Amendment Act 2005 is in possession of any land not exceeding 4 hectares in extent acquired by him or his WP number 25074 of 2008 predecessor in interest by the way of purchase or otherwise on payment of consideration from any person holding land in excess of ceiling area. During the period between the date of the commencement of the Kerala Land Reforms Act 1963, the date of the commencement of the Kerala Land Reforms Amendment Act 2005 shall be deemed to be a tenant, Section 7E of the Act.